My experience with national security letters began in 2004. It's gone about 7 years now. For most of that time, I've been completely unable to talk to anyone about what was going on in my life, including my colleagues, including my family, including my girlfriend that I was living with during all this time. And it put me in a very difficult ethical position, I felt, because I believe that people in the telecommunications industry are almost like medical workers or psychiatrists, in that they have access to incredible amounts of really personal information. The information includes, everyone you talk to, everyone that you correspond with, everything that you read, and possibly things that you might write on the internet. And that's just talking about internet stuff. That doesn't even include telephone stuff, which also includes geographic data about literally where you physically travel. What happened to me in 2004 was I was going about my day-to-day business, which mostly related to hosting websites for organizations and sometimes individuals. And I got a telephone call saying that an agent would be coming by with a letter. It seemed very mysterious. I wasn't even sure if it was true or not until an agent showed up and pulled a letter and gave it to me. I opened it up, and it directed me, that was the specific language, to deliver information on one of the clients of my internet company. It listed, I believe it was 16 categories of information. It was a lot of information, really broad. Unfortunately, I guess I should sort of preface this discussion by saying that I'm still mostly under the gag order, so I can't actually describe to you the types of information that were sought. I can't tell you who the client was or what they did, but I can tell you that most of the clients that I had were either businesses that you know well, like Mitsubishi Motors and IKEA and Snapple and people like that, or independent media outlets and things like that. So, I wasn't hosting anything really off the wall. In any case, I in the presence of the agent, I read the letter. The letter said that I wasn't to tell anyone that I'd received the letter. And that, immediately raised my eyebrows and kind of surprised me. And I said to the agent, does that include my business partners? Does that include my lawyer? And I was just kind of, thinking on my feet while just having read the letter. The agent didn't really answer me and kind of shrugged, and didn't really get an answer to that question. And then the agent had me sign a receipt and left. And then I was left to kind of digest this information. I found it very intimidating to be directed that I had to provide this information, that I couldn't tell anyone. But I had studied law a bit as an undergrad, and I've always been kind of a political person, and I thought to myself that, there's no way that I can be prohibited from speaking to a lawyer. So the first person that I called was my lawyer. When I told my lawyer what had happened and he read the letter, he seemed to agree with me that there was something very wrong with it, and that he thought it was potentially unconstitutional. And one of my clients at the time that I hosted their website was the New York Civil Liberties Union. So we got in touch with them, went over to their offices, showed them this letter, and they had never seen one before. And when I heard that, I got really nervous, because it seemed like I was kind of a bit into uncharted territory. At that point, some attorneys from A.C.L.U. got involved, and the long story short, we ended up filing a constitutional challenge in the court system to question the constitutionality of the national security letter statute. But what happened was, because of the gag order, and because this was sort of a new precedent, the case had to be filed under seal. So no one really knew what the case was about or any of the details. And it took weeks and weeks before it even became public that there was such a case. But even at that point, the case was known as Doe versus Ashcroft because my name and my company name couldn't be made public. I was never allowed to attend any of the court sessions. Only my attorneys could go, and then they would come back and tell me what had happened. In New York, they don't allow cameras in the courtroom, so it's not like I couldn't see video or anything. I could just read what had happened. And this went on and on for years and years. It went on so long that when the case was originally filed, it was called Doe versus Ashcroft, and then after Mr. Ashcroft left, it became Doe versus Mukasey, and then after Mr. Mukasey left, it became Doe versus Gonzalez, and finally, it ended up being called Doe versus Holder. I mean, it went a long time. Meanwhile, even the attorneys I was working with at A.C.L.U, there was some turnover there, so I went through 3 attorneys, and it ended up going on for about 7 years. And what happened was, we kept winning. We won at the district court level. The law was ruled unconstitutional, that it violated the First and the Fourth Amendment. Then the government appealed that decision, so we went to the appeals court, and again we won, but then there was a bit of an asterisk at that point because the Congress had gone back and amended the law, and thankfully they fixed some of the First Amendment issues, but the underlying issue of being able to perform a search without first going to a judge and showing probable cause remains, and that was really, to me, the central issue. The First Amendment issues are incredibly troubling, and they still mostly exist, but thankfully, they changed the law a little bit. But the snag that created for the case was that now the law was different. I had challenged one law, now there was a new law, and so they kicked the case back down to the lower court, and this was already 3 years into the whole experience. So at that point, soon after that, what happened was the FBI decided to withdraw the actual request for information. They decided that it was no longer important or necessary, even though it had been so urgent before. But legally, what that did was it sort of mooted my argument under the Fourth Amendment. Since they were no longer asking for this information from me, I could no longer say, hey, this violates the Fourth Amendment. And it turned out that in several other cases that were subsequently filed after me, including the really famous one with the Connecticut librarians that started maybe a year and a half after mine, the FBI also withdrew the request. And it began to kind of form a pattern that if anyone ever challenged the statute, they would withdraw the request, which would moot the basis for the lawsuit. In any case, as time went on, the A.C.L.U. and the EFF began to do a lot of Freedom of Information Act requests on this technique, and we began to learn more about what was going on. And what we found out was, a few statistics. We didn't really get a good overview of everything that was going on due to secrecy, but we would get little peeks behind the curtain, and sometimes there would be information like between 2003 and 2006, there were approximately 200,000 national security letters put out. Now, if you sit there and do the math, if there's 300 million Americans, that's roughly 1 per 1,500 Americans, which is already kind of extreme. But then as time went on, there were more stories that came out. It turned out that at New Year's Eve 2004, the FBI used a national security letter to get a list of every single person that had visited Las Vegas for New Year's. And this was in the range of 300,000 people. So I say that it's 1 in 1,500, but that could be a very conservative estimate because they were using these blanket national security letters to get information on tons of people. In many cases, the target of a national security letter whose records are being sought is not necessarily suspected of a crime. One of the things that we found out through FOIA is that the FBI was using the letters to obtain data not just on individuals that they were interested in, that they saw as targets of an investigation, but they were also requesting information on the network of people that person was in touch with. So it was sort of like a data mining technique where it would be like a social network, and they would be able to map out every person that knew that person and then everyone that knew that person. So they would sort of branch out to like the famous 6 degrees of separation. The challenge in the courts continued, and you know, despite having to go back to the lower court, when we went back to the lower court the second time, we won again. It was the same judge, and he found that the new statute was still unconstitutional. That, I think, was the point where the FBI withdrew the request. I suspect because they thought they were going to keep losing. And what happened to my case is that the scope of the case became more and more narrow. Whereas at the beginning, it was going to affect the whole country if we could get to the Supreme Court and they would uphold that decision. By the end, we were just kind of arguing about my personal free speech rights. And to me, it almost didn't seem worth it because I was more concerned with the broader picture. And I didn't want to just argue about myself. So about 6 years into the case, we proposed a deal with them where if they would let me at least partially out of the gag, we would stop suing them. So what they agreed to, and this took months of negotiation, was that essentially I could admit that I was the plaintiff in the case, and I could talk to you in generalities about the case, but nothing specific. And anything that had ever been redacted in the documents, I could not talk about. Through 6 or 7 years of court proceedings, you know, there was a stack of documents like this high, and many of the pages were completely redacted. So the amount of information I'm not allowed to talk about is just tremendous. In fact, every time I speak in public about what happened, I feel like I'm taking my life into my own hands because, you know, technically I could face 5 years in prison if I accidentally say one of the facts that was redacted that I'm not supposed to talk about. But to me, it's such an important issue that I'm willing to take that risk. I don't know how many other people who work or worked in the telecommunications industry are gagged the way I was. Because of the secrecy involved with this issue, we just don't know that, but we can kind of surmise that it's a lot of people. And you know, I feel that as a person that's been partially released, that I have some responsibility to sort of spread the word and explain that there's a lot of people out there who have kind of coercively been made not to talk. You know, your right to petition for redress of grievances is basically over once you've gotten one of these gag orders. You can't write to your senator or your congressman. You can't you know, you can't even talk to your friends about it. You can't go to industry meetings and try to say, hey, does anyone else have this experience? Because no one else will answer you because they're all under gag orders. So what I think about the gag order is that it's really destructive to the idea of having an open and public debate about the issue. If only I can talk about it and only in broad generalities, then how are we supposed to hash out the issue? You know, what about all these other people? Why can't they talk about it? In the end, I kind of felt that I could do more good on this issue by speaking out publicly, even if I was still prevented from getting into specifics. And so what I decided to do was try to start a nonprofit organization whose goal is to promote best practices with regards to privacy in the telecommunications industry. Because I feel that people who work in that industry have a tremendous responsibility for, you know, the reasons I explained earlier. So basically, where I've come to is that I'm trying to do as many speaking events as I can, and this is about the third or the fourth one that I've done, just to explain what happened. So, I mean, to sum things up, I want to say that actually I agree really strongly with what Tim said, in as far as I don't feel that the national security letter statute is something that can be repaired with tweaks here and there. You know, in a way, it makes me feel like saying, like, I want the America back that I was taught about in school. The one where there's checks and balances, and where one branch of government can't do everything on its own. I think that the FBI, if they want to get information on someone, should have to go before a judge and show probable cause. Because that's what I learned in my constitutional law class when I was in university, and that's what I learned in grade school. And And that's essentially what I would like to advocate for. So in any case, I want to thank you for your time. Yeah, that's pretty much my talk. Thank you.